I am very proud to be here with you as member of the executive board of ASCOLA. And it is also a pleasure for me to be here since I'm about to publish together with two colleagues, Joe Cannataci and Oreste Pollicino, a book which is quite intense, new legal challenges of big data. So it's really a pleasure to be here, and it is really a pleasure to welcome these very nice panelists. I asked first Can and Bertin to take the floor. They will comment on governing agricultural data and competition in the data-driven agricultural services, a farmer's perspective. Can is a PhD candidate at the Tilburg University, and Bertin is a PhD working at the European Commission. So I welcome both Can and Bertin, leaving them the floor. Thank you.
Thank you, Professor. As you said, we are going to speak about governing agricultural data from farmers' perspective. I'm starting. Although there might be a perception that agriculture is a totally rural activity that is far from technology, agricultural production is getting more and more data-driven day by day. Based on this smart farming revolution, some companies provide data-driven agronomic solutions to farmers in agricultural decision-making processes. For instance, estimating crop yield, harvesting times, suggesting irrigation, fertilization, seed applications, tracking and preventing plant diseases, and providing suggestions about how to deal with them. In order to provide digital agriculture services to customer farms, companies need to combine three types of data, namely farm data, complementary data, and proprietary data. The farm data component makes the services tailor-made to the specific farm. In order to identify the legal status of agricultural data, it is critical to be aware that this information is about farms, soils, crops, animals, etc., not related to individuals. In this regard, it is difficult to consider them as personal and apply GDPR rules. Indeed, the regulation on free flow of non-personal data also consider farm data as non-personal. However, this regulation does not provide detailed allocation of rights, unlike GDPR. It mainly provides a general framework for sectoral data governance principles. In the absence of clear regulatory framework, stakeholders in the US and EU independently developed two voluntary data charters and proposed some rules about ownership, data collection, access, control, portability, and some other concepts borrowed from the GDPR. They are not binding. Enforcements are based on contracts. In the US principles, there is an organization that audits companies' compliance. In our paper, we first compare these voluntary charters by mainly discussing whether legal designs of these charters are effective enough to achieve a more competitive environment in the sector that also mitigates farmers' concerns. In the second part, we discussed the sources of economic efficiency gains from agricultural data, business models, potential data market failures, and possible responses to address them. I will briefly mention some of the proposed rules in these charters and provide a general consideration about them. First of all, both charters use data ownership as the legal concept and attribute original rights to farmers, even though EU code has some ambiguities on whether other parties can also be the data originator. Similarly, both texts emphasize data generation as a result of farming operation. With regards to the data reuse access, data owners should provide explicit consent. However, rights are not absolute for farmers. Both texts emphasize that contractual freedom is above the proposed rules and principles. Similarly, in the US principles, portability can only be possible if contract lets farmers to do so. In here, anonymization is stated as an exception, but the notion seems inconsistent with non-personal agricultural data. EU code is a bit ambiguous unless otherwise agreed in the contract. Emphasis triggers a possible interpretation that there is by default portability right unless it is explicitly renounced by a contract. However, the following sentence starts with if agreed between the parties, just like US principles. So it's ambiguous The EU code adds a limitation borrowed from the GDPR, technical feasibility. As a general consideration, the US and EU agricultural data charters seem to transplant some basic GDPR principles. However, they are not always consistent with non-personal farm data. Additionally, primacy of contracts over principles makes these voluntary initiatives functionless to a large extent, because it maintains statistical based on free contractual relations. More importantly, attribution of original rights in both texts centralizes data ownership as legal concept. However, alienable ownership rights can be transferred to third parties, and farmers may lose their control on data permanently. This can be a more serious risk when considering farmers' weaker position vis-a-vis companies and their standard terms and conditions. This design would only turn technology providers' de facto control on data into a de jure situation. In such an environment, even if these voluntary principles become legally binding texts, it's hard to see how they could correct B2B agricultural data market failures. Therefore, it can be argued that binding and inalienable sui generis rights can be designed to address specific market failures in the sector, instead of using ownership concept or in transplantation of GDPR concepts. On the other hand, instead of linking rights and farmers as individual persons, rights might also be associated with farms as agricultural production units. Thus, if the business changes hands, then the associated data rights can be used for the sake of continuity of agricultural production. Multiple stakeholders might also use data instead of exclusive structure of the ownership understanding. This might be more compatible with the non-rivalry of data. That's all for the legal part, first part. Dr. Martens will continue in the next slides.
Thank you, Can. So let me take over here with a few more economic considerations. As Can argued, these US and EU data charters in agriculture will not really change the allocation based on market-driven contracts negotiated between farmers and agricultural service providers. So what is this market-based allocation of data? So in order to find out about this, we're going to look at, first of all, at some basic economic characteristics of the data, and then see how this works out in the market and what sort of allocation of benefits and costs this leads to. So in data economics, we consider three sources of welfare gains or efficiency gains from data. First is from economies of scale. Larger data sets usually lead to better predictions and better insights, but they are subject to diminishing returns. So there's no eternally expanding data set will not lead to externally expanding efficiency gains. There are limits to that. The second source often discussed is economies of scope in reuse of data, because data is not rival. It can be reused and applied several times by several parties. So this is an argument in favor of data sharing between different parties, different firms, farmers and firms. And there can be efficiency gains because the data only have to be collected once and then be used by several parties. The third is economies of scope in data aggregation of complementary data. This factor is often underplayed in many papers. This is a factor that favors data pooling because it suggests that the larger the pool of data is that you can collect, the more insights and the more valuable insights you can extract from these data. So there are efficiency gains for that. And so this is an argument in favor of creating big data pools and concentration in large firms. So monopolization of data in a way. So there are some important consequences of these three sources of welfare gains from data. First of all is the social value or the collective value of data exceeds the private value to farmers. Now, this is a definition of market failure. And it also shows that private allocation rights are probably not going to be the best mechanism to allocate these rights. Achieving that social value requires an intermediary, a platform, a data collector who collects all these data. So that platform is going to be in a monopolistic position, either due to network effects or to data lock-in effects, which we'll discuss in the next slide. So the question then, the policy question then becomes, should regulators impose some sort of remedy on this to avoid this monopolization? Next slide, please. So in reality, these intermediaries do not fall out of the sky. They emerge out of existing operators already in the agricultural sector. One is machine manufacturers. John Deere, Sperry New Holland, tractors, combine harvesters, milking machines, all kinds of machines in the agricultural sector. These machines contain sensors that collect data, and they contain actuators that allow a farmer to implement a specific protocol or instructions in his field or in his farm. Now, machines are designed in such a way that the data are locked into that machine, and only the machine manufacturer has privileged access to this. So this may lead to foreclosure of complementary agro services down the line. A second source is agriculture input providers, chemicals, fertilizers, seeds providers, and so on. Their proprietary knowledge of inputs, which they try to sell through devices that they sell to the farmers, sometimes via apps on their phones, but also via hardware devices. This may lead to self-referencing of their own products, which again is not a good thing from a competition policy perspective. A third option for farmers is to go through their farm cooperatives, and there are many of those that exist in the agricultural sector. Now, the problem there is that how are these cooperatives going to monetize their data-based business model? Farmers can pay the cooperative to handle their data, but this is not a very attractive proposition because the market value of individual farm data is extremely low, so they would pay more than what the data are worth, in fact. Other cooperatives have gone for service provision, but then the farmers have to pay again for that service, and then they fall back in the position in the two previous options. It has often been suggested that data portability is a way to overcome this lock-in. This may be true in some circumstances, but does it increase or does it reduce competition? And which data can be ported? The data contributed by the farm, or also observed data by the intermediary platform, or inferred data through data analytics? Next slide, please. Let me skip the first part of this slide and go straight to the policy questions. I think one of the key questions in when data economics and data platforms meet competition policy is that we are torn between the efficiency gains from creating big data sets and, on the other hand, the monopolistic behavior of these big data platforms. There are also equity concerns in that because benefits accrue to the farmer, to the platforms, not to the farmers, because the locus where the value added and the social value of the data is gained is in the platforms. Is data portability a solution? It makes circumvent lock-in and may increase competition, but it may also strengthen the network effects of these large platforms. And so it's not sure that this is a solution. Thank you.
Thank you. Thank you very much to you both. Very interesting presentation, very original presentation on a hot topic. Shall we have someone wishing to ask for question or commenting on the agricultural issues? If not, oh yes, Simonetta, please.
Hi.
First of all.
Thank you so much for the very interesting presentation. I learned a lot. I'm following a little bit the EU data strategy, and one of the ideas there would be to imagine the creation of something which is called industrial data space or international data space. I don't know if you had a chance to have a look at it and perhaps your take on it. So that the idea would be that it would be a sort of decentralized solution based, why not also blockchain, but many other ways. And it's part of the Gaia X initiative. I don't know, perhaps you had a look, perhaps you hadn't, but I would be curious to hear from you.
Can I answer this question?
Sure, please, Bart.
Yeah. So this data strategy for creating industrial data platform falls in what I, as an economist, would call economies of scope in reuse of data. So you share data with other parties. That overcomes one problem, namely non-rivalry of data, and so savings in the reuse of the data. But it may create other problems, which is that data may fall in the hands of your competitors, which is not something that you may like. Data may also spill over, and you lose your data rent if data are too widely shared. So you need to control this a little bit. And so intermediary solutions, intermediary data governance solutions, where the pool is managed between but a limited number of operators, might be a good solution there. The question is, who can join the pool and under what conditions? So there's a lot of debate about the conditions for the management of these data pools.
Thank you, Bertin. And maybe I can add a further question on the same topic. You were both referring to us why generis right. So I was wondering, in your opinion, which are the legal bases for introducing such a new right? Thank you.
I think introducing rights should be based on addressing specific market failures instead of choosing a well-known legal concept such as ownership. Because as I explained, ownership might be problematic. It is transferable. And if it is transferred to powerful parties, there will be no mechanism to protect farmers' rights. For instance, the right to data portability might be useful, as Bertin explained, and the other access rights via these intermediary platforms might be useful, but that is the question of maybe another study. We haven't developed that much insight on that right now.
I recall a very nice piece of paper from the Max Planck Institutes on data rights based on IP, intellectual property grounds. So this could be maybe an interesting path to consider. Other quick questions or maybe any possible reply to what we said? If not, I thank you, both of you, very, very much, and I'm looking to read your final paper. I would now like to give the floor to Giulia Schneider. Giulia is a postdoc researcher at Sant'Anna Pisa, so it's a double pleasure to introduce her, not only for being a very talented scholar, but also sharing the same nationality. Giulia will talk about designing data pools, which data protection safeguards for emerging remedies. So Giulia, I leave the floor to you. Thank you.
Can you hear me?
Very well.
Perfect. Okay, thank you, Professor Falce. I hope you see my screen that I just shared. My presentation today relates to the interaction between data protection law and competition law in the specific case of the regulation of data pools, and especially in respect to the very hot topic now regarding whether and how competition law can intervene into opening up established data pool in the form of an outright sharing remedy. So, of course, the interaction between data protection and competition law has been now a traditional and a very established topic in both scholarly and political analysis. But in respect to, and in particular, of course, the big question has been whether data protection violation can be relevant for the purposes of competition law. So the perspective of data pool actually opens up a whole area of new questions related to the interaction between these two regulatory branches. And in particularly, my question was related to how data protection law the consideration of the data protection framework can sort of guide and shape eventual sharing remedies under competition under competition law. And in this respect, I was questioning whether the data protection law offers specific opportunities for the design of competition-based sharing remedied over data, and whether a data protection law entails some limits that equally can guide the design of competition-based sharing remedy. Now, in order to address these questions, my research has started to address a set of sub-questions. First of all, what are data pools? Then at a more general level, how do data protection and competition law address innovation goals? In order to inquire in whether under a traditional competition law there are already some information-based sharing remedy. And from the evidence drawn from these three questions, I have tried to look more deeply at which data protection safeguard can be relevant for emerging data sharing remedy. Now, in order to frame the issue, of course, as you may all know in this panel, data pools are a sort of contractual based or ordering tool shaping data-driven innovation courses. So what is relevant is that data pools are an outright form of information-based alliance that are established in order to aggregate data exactly for research and development purposes, and that is for broader innovation purposes. So what is interesting to highlight is that the pooling and the aggregation of these data can occur under various contractual schemes based on, depending on the object of the aggregation and of the pooling, that is whether solely data or also the technology, the private or public nature of involved parties, and the purposes, if specified, for the aggregation of data. So in respect to traditional technological pooling, as for example patent pooling, the main difference between the main distinctive element and feature of data pools is exactly that it is very difficult to establish beforehand what is exactly the object of aggregation. And in data pools, this results also into a very difficult identification of data ownership and liability rules. In patent pools, normally this was more clearly identified, for example, in the standard setting agreements. Now, data pools have been object, and the data sharing more broadly have been object of also many European policy documents, where the Commission actually tried to incentivize data sharing and highlighted the importance of data sharing for efficiency purposes of the internal market. As they were more just now mentioned, also the European data strategy, which was very recently enacted, actually takes into consideration the possibility to establish outright data spaces. So always in the perspective of the creation of data sharing zones. But of course, this free data sharing and this free contractual sharing, which also under European policy documents is always regarded from the perspective of the free contractual sharing of this information, encounters some limits. And these regulatory limits are, first of all, to be found in data protection and competition law. Data protection, why? Because most of the data that is shared is of personal nature, especially in consideration of the very broad notion given to personal data under the General Data Protection Regulation. And of course, also competition law can become a limit to data sharing practices there where the established data pools become of a closed nature. This meaning blocking fruitful information interaction among other market players, and thus ending up blocking the process of cumulative innovation, which is exactly based on these data, generating anti-competitive harms. Now, but let's look a bit more generally about the regulatory function of data protection and competition law in respect to the goal of promoting innovation. Indeed, we have said that the basic rationale of data pooling is exactly the innovation rationale. So in this light, it is very interesting to highlight that both data protection law and the most recent European competition policy have very much highlighted the importance and have very much promoted innovation goals. Indeed, the General Data Protection Regulation has not only the main goal, of course, of protecting data subjects' fundamental rights in the digital economy in respect to the processing of personal data, but as a second pillar of the whole European data protection framework, there is the one of the promotion of the free flow of personal information, of course, in a fundamental rights compliant perspective always, but the goal of the free flow of personal information is the second sort of main goal of the General Data Protection Regulation, recognized and acknowledged in many recital, and particularly recital 13, which highlights the importance of the sharing of personal information exactly for the efficiency of the internal market. And one mostly important for our purposes, recital 123 of the General Data Protection Regulation exactly acknowledges the importance of the role of data protection authority in the enabling of the flow of personal information, of course, always in a manner that is compliant with the General Data Protection Regulation. And from a horizontal perspective, that is from a business to business perspective, European competition policy has recently gained greater attention to competition and innovation purposes. And innovation is itself increasingly regarded as a competitively relevant parameter, especially in recent merger cases. So exactly under an innovation rationale, it is interesting that we can draw a sort of parallelism between data protection law and competition law. Indeed, both frameworks appear to establish access enabling regimes of information under exactly a research and innovation rationale, which could possibly legitimize actually the contractual trading of data and thus the creation of data pools. So we're in the moment of the initial creation of a data pool. The reference under data protection law is given by the so-called research exemption, which exactly facilitates the further processing of personal data for research purposes, actually establishing also a set of very important derogation regarding basic data subject right and data protection principles. First of all, of course, the principle of purpose limitation and other important data subject rights as the right to be forgotten, exactly in light and in view of a research purpose of these processing. And a parallel can be drawn in this regard in respect to the research and development block exemption, which also regards and treats research and development agreements, which can also be based on the sharing of and the transfer as the horizontal guidelines, specifically a knowledge of information. And so there are these access enabling regime which can provide actually fruitful conditions for the creation of data pools in an incentivizing perspective regarding data sharing, but of course under both these frameworks specific also conditions are set. Indeed, under Article 89, the GDPR requires data controller and thus undertaking to establish specific data protection safeguards, which are unfortunately not better defined. And as you may all know, also the research and development block exemption establishes specific conditions, also in terms of the open nature of established information alliances that are, of course, a burdensome condition for undertaking engaging in the pools. And thus, in this perspective, among the relevant data protection safeguards that can be relevant for the creation, in the moment of the creation of the pools, of course, information obligations onto data controllers must be recalled. And in the moment of, and competition law sets a further condition, let's say, to the creation of data pools, in the a further limit for the creation of the data pool at the subsequent moment of the creation, the occurrence of an anti-competitive harm. And thus, competition law entails elements of intervention in terms of information sharing remedies. Now, information sharing remedies are entail and are a product of traditional competition law analysis. Indeed, especially in high technology market, information sharing, information collaboration have been looked at in respect to the informational advantage they give to members of the pool. And competition law has intervened exactly in the moment where the established information collaboration has impeded further information flow among participants, in this way compressing innovation and harming market participants and consumers. Example of these information-based share remedies, which can be found under the traditional European competition law framework, are not only to be found, and this I found very interesting, under the Essential Facility Doctrine framework, that has been much developed, especially in the Microsoft case, which exactly mentions the need to stir technological progress through the imposition of a sharing obligation onto the dominant company, but also in merger decision. And we can find in these cases a sort of information sharing remedy exactly in the remedy of the divestment of research polls that have been required in many merger procedure, especially in the pharmaceutical and in the chemical market, where it has been highlighted how exactly the aggregation of research polls that are nothing else than information polls were resulting into a compression of the innovation and incentives, the incentive to innovate on the broader market. And so we see that both these information sharing remedy, both under the Essential Facility Doctrine and in merger procedure cases, are exactly rooted into the recognition of a harm to innovation, and have the exact function of opening up established information alliances in order to make information circulate among market participants for efficiency purposes. Now, the question that the scholarship is now dealing with is whether these traditional sort of information-based sharing remedy can be applicable to data pools, for the opening up of data pools in the digital economy. Now, of course, there are many shortcomings. First of all, related to the theoretical problem that competition law cannot have a structuring intervention into market and must be related to a harm to competition. And this is very difficult to establish in the case of data pools. And there are also operational problems in terms of administrability problem to the definition of the terms of an eventual sharing obligation posed onto data pools. So very quickly, I have asked myself which in these uncertainties which have led some a strand of the scholarship to deny the possibility to establish an information sharing remedy for the opening up of data pools, I have asked myself which can be the support, and if any, the support from the data protection framework. And I have highlighted some opportunities and some limits that can guide the shaping of an eventual data sharing remedy over data pools. In this regard, I see that a first opportunity can be given exactly in respect to the information, to the very sophisticated information that data protection authority have in light of their auditing powers under Article 30, 35, 36, and especially 58 of the General Data Protection Regulation, which enable.
I need, sorry to interrupt, but I really need to ask you to get to some preliminary conclusions so as to be able to open, I'm sure.
Yeah, I'm sorry. Okay, I'm just finished. So this can be a first opportunity in order to shape in the perspective of the collaborative governance of a sharing remedy between the two authorities. And further limits can be given by, for example, data protection principle as the principle of transparency and the principle of fairness, which are which are the fundamental pillars of the General Data Protection Regulation, which could help competition authorities to establish, to identify, for example, the addressee of the sharing obligation and appropriate threshold. Now, so my conclusions is that in this slide, there can be a mutual supportiveness between data protection and competition law in the regulation of data pools, and data protection and the data protection safeguard framework can orient and facilitate competition remedies in the form of data sharing remedies for data-driven innovation purposes. Thank you.
Thank you very much, Julia. I'm very sorry to ask you to speed into your conclusions. I just leave the floor to who would like to raise some questions or comments. Well, I can start myself, and I would like to ask you, in your opinion, which could be in practice the regulatory framework you were referring to. So who should be the authority able to enforce and competent to apply these new set of rules, or you imagine a shared competence by different authorities? So I would like to have your opinion on that, since in Italy we're also discussing about a super, and also at European level, a super authority governing data markets and data overall. Thank you.
Yes, actually, my assumption was that these data sharing obligations should be enforced by competition law authority when a harm to competition, of course, is identified. And for these purposes, actually, I was suggesting the exploitation of the information that data protection authorities have regarding the nature of the data pooled together, the structure of the pools, that can be an essential information, in my opinion, in order to identify this harm and thus to justify the intervention by the competition authority. But of course, in the perspective of a joint governance between these two authorities, we could actually also think about exactly a shared competence, since as I already tried to highlight, data protection and competition assessment are, in the case of data pools, strictly interrelated.
Thank you. I will now leave the floor to Björn. First, I like to say hello to you. And and please, would you like to go?
Sure. Thank you very much for the possibility to ask questions. Thank you for the presentation, Julia. It was very interesting. I had a couple of questions. Also, I think that research exemption on the GDPR, I'm not a GDPR expert, so I had a question about that. Does that apply also to private R&D collaborations? That was my first question. And then my second question, I think that what you call traditional information sharing facilities, and you refer to McGill and IMS Health and Microsoft and so on. At least in Microsoft, there was an information sharing remedy, but isn't it kind of difficult under competition law to force collaboration in between firms? To be perfectly honest, I think the only case I know about where there's forced collaboration is this old US Aspen skiing case, where they had to share a common ski pass, and which was quite simple collaboration. But start to share your business data. I can see the problems there when you try to when you're getting these firms to actually do it. So that was perhaps more of a comment. Or if you have found any cases where forced collaboration, I would certainly be interested to hear that. I also had the third is a more broader question. If we would suggest a data property right, perhaps where the boundaries for that is identified by blockchain or whatever you have it. Could that be a solution to this? The problem that a data pool would probably have overlapping data or have competing data sets in it, so to say. So you get it more to be like a patent pool.
I need a very quick answer, Julia, since we are over time, unfortunately.
Okay, no, I will be very quick. Regarding the applicability of the research exemption to private collaboration, of course, because the General Data Protection Regulation applies both to public and private entities who just come to process data. So this is, yeah, the idea of forcing collaboration, I see the point that it's complex, and I want not to be critical regarding that. But I found interesting actually the in the Microsoft case, of course, it's the traditional case that we can think of, but I found particularly interesting the merger cases and the merger decisions, because there I think that exactly the divestment of research polls is an exact example of this, not forcing from nothing a collaboration, but forcing a collaboration as a result of an already established collaboration in order to make data and the information flows to keep the rhythm of these information flows. With regards to data property, yes, this could be also through the solution of blockchain technologies. That would be a good idea in order to identify better the data sets that are object of the obligation. But I think actually that also without recurring to a data property right, the data protection law, I think, already entails sufficient elements of identification, exactly in view of these auditing powers the data protection have. And these auditing powers, I think, when it comes to personal data sets, of course, but I assume that most of course, there are markets in which personal data are not there, but I think these auditing powers should be sort of maximized also for competition law assessments. Of course, and if I can close this, of course, open up the problem of the competences of different authorities and of overlaps of different authorities. But I don't see there much the problem when this information is already there at the data protection, that the data protection authorities already are in hold of this information, and so then can subsequently share the information with the competition authorities when it's needed, as also the European Commission is suggesting, and the European Data Protection Supervisor. So I don't see there a problem of competence.
Thank you, Julia. I just need to ask Alio to maybe postpone your questions since the following topic is also on data pools. I would like now to give the floor to Martina Anzini and Anne-Carine Pierrat. Martina and Anne-Carine are policy analysts at the Center of European Policy, and they will talk again on data pools as information exchanges between competitors and antitrust perspective. So thank you, Martina and Anne-Carine, to take the floor and allocate the 12 minutes that we needed to respect. Thank you to you both.
Thank you. Today we will present our paper entitled Data Pools as Information Exchanges Between Competitors and Antitrust Perspective. We will first define a data pool, then we will present when it can qualify as an anti-competitive information sharing agreement under EU law, before addressing whether it could pass the efficiencies test of Article 101.3. We will finish with some conclusion notes. In relation to its investigation into Insurance Ireland data pooling system, the Commission defined a data pool as a data sharing system with an element of reciprocity, so whereby at least some companies will provide data. While data pooling is key for commercial success and is therefore generally pro-competitive, it also raises antitrust concerns. We focused in our paper on the risk of qualifying as a forbidden information sharing agreement, especially whether the existing legal standard of review is suitable for data pooling.
So when assessing whether data pools qualify as anti-competitive information sharing agreements, antitrust authorities have to face two problems. The first one is to identify a sound theory of harm for information exchanges as a standalone business practice. And the second one is ascertaining when data pools can be held equivalent to information exchanges, as data does not necessarily equate with information. Concerning challenge number one, it must be understood that the antitrust economics of pure information exchanges between competitors is very complex. So such complexity lies in the fact that information exchanges can produce different effects on the market. So on the one hand, they can enhance efficiency by allowing the diffusion of the best business practices or allowing parties to better handle unstable demand. In certain sectors, such as the insurance sector, exchanges can even mitigate market failures which are triggered by information asymmetries, such as adverse selection and moral hazards. On the other hand, information exchanges can turn competition into a potentially anti-competitive form of cooperation. For instance, they could allow parties to the exchange to target new entrants, and they could put unaffiliated competitors at a significant competitive disadvantage as compared to parties in the exchange. So, first of all, so the Commission has given due consideration to those facts within its guidelines on horizontal cooperation agreements. So it has established that information sharing infringes Article 101 TFEU when it produces a collusive outcome or an anti-competitive foreclosure. It has also identified a few key indicators of anti-competitiveness, such as a transparent and concentrated market or the strategic and individualized nature of information. However, the Court of Justice seems to point in another direction when it comes to defining a theory of harm for information exchanges. This is particularly the case when one considers the John Deere case, which is the first case where the court ever dealt with the anti-competitiveness of pure information exchanges, and in our opinion, the most articulated. It concerned an information exchange system established by a group of British tractor manufacturers, exchanging data about the registration of agricultural tractors. The reasoning of the General Court was the following: in that specific market, competition was already pretty weak because the market was oligopolistic and because it was characterized by high barriers to entry. So what preserved competition was that sort of veil of ignorance wrapping competitors and preventing them from getting to know certain facts. The fall of such veil of ignorance due to the information exchanged pushed the situation beyond the breaking point by a competition law point of view, and this justified the finding of an infringement. So in this case, one might say that the General Court supported the erosion of uncertainty or softening of competition as the relevant theory of harm. The parties to the exchange contested this reasoning in the appeal by pointing out that an information exchange can bring about good as well as bad transparency, and the reasoning of the General Court did not explain why this case in particular fell in the bad transparency box. The Court of Justice, however, said that the reasoning of the General Court was sound because it demonstrated that the exchange altered the conditions of competition in a way that did not correspond to the normal conditions of competition. So in a way, the Court of Justice confirmed the correctness of the approach chosen by the General Court. On the other hand, it highlighted its shortcomings because it entails know what the normal conditions of the market are, which is arguably no easy task. So in conclusion, we can say that the Commission and the Court of Justice of the European Union have similar view when it comes to identifying relevant indicators of anti-competitiveness for information exchanges, but that the theories of harm that they consider as relevant significantly diverge. The second challenge is to fill the gap between data and information. So data does not necessarily constitute information. When does data constitute information instead? Well, data is but a factor of production in producing information. So in this sense, we said in our paper that it needs framing to become information. And we described framing as the existence of the necessary conditions required for the market operators to grab the meaning of raw data for their business reality. There are, in our opinions, two possible scenarios that allow framing. The most obvious one is the one where data pools are complemented by a common technology that builds predictive models, such as an artificial intelligence tool. In the alternative, the economic and/or legal context can provide the necessary framing tools to create the framing effect. For instance, if the market is oligopolistic and the parties to the pooling are active in the same market, some framing effects could be produced. One has to consider whether it is sufficient. The fact that data can equate to information does not mean that it will. So in the context of information exchanges, there is a presumption that the shared information is used by the parties to the exchange to determine their conduct. In data pools, this presumption cannot really operate because each data pooler might or might not have the ability to extract information from data. So it is important to establish an analytical model to assess when and under which conditions such presumption can operate in the context of data sharing. In this respect, we propose three possible models. So the first one is the paradigmatic data pooler model. In this model, according to this model, the antitrust authority needs to establish a paradigmatic data pooler. So a data pooler with average data mining abilities, taking into consideration the level of technological advancement and the most widespread technologies in the relevant sectors. Then the antitrust authority needs to check whether the paradigmatic data pooler would be able to turn data into information. The second model is the statistical threshold models. In this case, we do not look at the data pooler, but at the data. And we statistically elaborate how likely it is that data can be turned into information. If the likeliness passes a certain threshold, then the presumption can operate. Third, we propose a corrected statistical threshold model, according to which there must be circumstances that confirm the correctness of the conclusions reached to the statistical threshold model. This means that, for example, if the data pool agreement entails regular payments from one data pooler to the other, it means that data poolers must probably know what is the value of what they share and are probably able to turn data into information.
An anti-competitive agreement under Article 101.1 of the TFEU can still be found in compliance with competition law if it fulfills the four conditions of Article 101.3 of the TFEU. We will focus on the two first conditions, the efficiency gains and the indispensability of the restriction of competition, where issues can arise when applied to data pools. First, the anti-competitive agreement must produce efficiency gains which outweigh its anti-competitive effects. According to the Court of Justice, the efficiencies must constitute appreciable objective advantages, so that they are not assessed from the subjective point of view of the parties, but also they cannot consist of mere expectations. This might be problematic in the case of data pooling because it might lead to innovation, such as the development of a new product or a new service, but this innovation is unpredictable at the time of pooling data. The second issue concerns the indispensability condition, which implies that an agreement must be indispensable to achieve the efficiencies, so that there are no other ways that are economically practicable and less restrictive to attain the efficiencies. An alternative to data pooling might be to collect the same data directly from the customers. But in this case, the antitrust authority needs to determine whether cost consideration and data protection issues make this a true alternative for data poolers. To conclude, three elements can be underlined regarding the antitrust review of data pools under EU law. There is no unified theory of harm on information exchanges. Differences between data and information exist and need to be taken into consideration, and providing evidence of the alleged pro-competitive effects of data pooling might prove to be difficult. So these elements should be taken into consideration for the Commission's upcoming review of the horizontal cooperation guidelines. Thank you.
Thank you. Thank you very much, Martina, and thank you, Anne-Carine. The presentation raises many further questions and questions. So I now open the floor to maybe Alihu. Would you like to pose some questions to our panelists, since before I was obliged to interrupt you?
Not really. I don't have questions for her. Thank you.
Okay, so then maybe I have questions for you both. You were focusing on the possibility or the chance or the perspective of modernizing the horizontal agreement approach at European level in the sense of amending the data pools antitrust approach. I was wondering whether, in your opinion, talking about data pools would need to review also some rules or approaches concerning the type, structure, and the degree of concentration of the relevant market. Or do you think that in the perspective of the European Commission and in the perspective of the European institutions, the structure of the market would raise possible issues only if oligopolistic under a traditional perspective? Thank you.
But concerning this specific aspect, this specific antitrust issue that we analyzed in this paper, I think that the structure of the market is part of the context, must always be part of the assessment, but is probably not the focus of is not probably the key aspect, as it would be for other kinds of anti-competitive conducts, which could be perpetrated through the data pools. So I would say that yes. So I would insist more. I would focus more on horizontal cooperation.
Okay, thank you. Thank you very much. Are there further comments? If not, I really thank you both again, and I will leave the floor now to Shuya Hayaski, and I'm sorry if my pronunciation is not correct, and to Koki Arai. It seems that the topic is still very linked to the previous one, and I will ask them to introduce their presentation on artificial intelligence, big data, and competition. Thank you. We can see the presentation, but we cannot hear you.
Hello? Hello?
Yes.
Can you hear me?
Yes, now we can hear you. Thank you.
Oh, sorry. I'm Koki Arai, Professor of Economics at Kyoritsu Women's University, Japan. I miss having the opportunity to meet and discuss with you in person, but I find it new and refreshing to participate in a virtual event like this. I'd like to express my thanks to all those involved with ASCOLA for preparing and conducting the virtual conference in these difficult circumstances. I would like to thank you for the opportunity to present our work in front of you. I think we have 12 minutes and we'd like to finish our presentation as soon as possible within 10 minutes, I hope, because we want to have a lot of discussion with you. This research is joint work with Professor Hayashi of Nagoya University. Here's today's outline. Our presentation is a bit different from the previous ones and is about methodology. We know competition law and policy aim to ensure an active competitive process in the marketplace. In view of ongoing oligopoly of platforms, the Japanese government, as well as other countries, are working on this. Our paper examines the necessary and sufficient conditions for rules on digital platforms from the perspective of legitimacy and explains the need for cautiousness in treating policy efforts. Our specific recommendations are as follows. Intervention in competition variables should be minimized. Arguments based on empirical analysis are particularly needed. To ensure innovative AI-related R&D and fair competition, the governance of AI networking should generally be non-regulatory and non-binding, taking into account the technical characteristics and the apportionment of responsibilities among stakeholders. In slide 4 and slide 5, we are laying out the situation around IT and our lives these days. The basic rules are being discussed, and the aim is to promote transparency and fairness, digital society, and economic growth. Public opinion has shown strong support for the production of the public goods and for the active introduction of AI into what are costly for humans to do. In light of this situation, it is important to pay attention to the importance of proving appropriate alternatives and maintaining compassion when we planning to introduce the AI and intelligent machines and systems into society. The market dominance of the platform could be one of the points of contention. In light of these issues, we can identify 3 issues here. First is market power. What controls the market? That is the main concept of monopoly under the antitrust law. The second is how we measure market power. And the third is the abuse of market power and AI cartel problem. With regard to market power, to summarize what needs attention in the issue of market power, we will have to consider the idea of market power in the context of the data. And the second, the problem of measuring market power is very similar to the problem of the so-called R&D market. Various methods such as SNP and SSNDQ are being considered, and they are difficult to use. So this is a phase in which empirical analysis is becoming more and more important. With regard to the abuse of market power and AI cartel problem, for example, it is problem of restricting access to critical data. AI cartel is another problem, but careful consideration is needed for each situation, and the accumulation of empirical analysis is required. So our paper has 2 approaches. First, empirical estimation and theoretical discussion. They are not alternative, but complementary. And this paper is the theoretical discussion of methodology. We use theoretical and critical approach to use perspective of legitimacy. The circumstances where compassion law enforcement is necessary in the context of the development of ICT, and where compassion law enforcement is sufficient to achieve the objective are critically examined. We are examining the necessary and sufficient conditions for Japan's high-tech regulations from the legitimacy perspective. With regard to the necessary condition, we draw on the arguments of United States constitutional scholar Professor Farron. The argument describes legitimacy as firstly sociological acceptance, secondly moral legitimacy, and thirdly inherently relying on a foundation of uncertainty but acknowledged by expectations of the future. With regard to the sufficient conditions, we use the elaboration likelihood model analysis to test whether Japan's high-tech regulations are sufficient. And reasoning about causal relationships is also necessary. And it is necessary to consider whether the objectives can be expected to be achieved. And we have the provisional conclusions. But this is a kind of detailed one, so I skip one. And this paper examines the necessary and sufficient conditions for rules on digital platforms for the perspective of legitimacy, and explains the need for cautiousness in treating policy efforts. And we recommend interventions in competitive variables should be minimized in order to be assessed in a competition policy framework. This was our presentation. Thank you for your attention.
Thank you very much. Thank you very much for this very, very interesting presentation, which recalls also an international perspective, so how different jurisdictions and approaches can be considered. So I would now like to leave the floor to our participants for asking Koki and Shuya possible questions, so also for raising further issues. Well, I will take the chance, and I am very much interested in the Japanese approach, since it seems that it is not fully reconciled with the European one. So I would like to ask you if and which are the hints that you envisage for the Japanese environment to be taken from the European approach. Do you think that the European approach in terms of policy and in terms of Court of Justice case law can be of some example to the Japanese authorities and approach, or do you think that the US approach is much worthy to follow? Thank you.
Okay, thank you for your questions. It's our paper approach is a kind of methodology. So the data characteristics such as data two-sidedness or privacy protection, when applying this methodology is a kind of similar one. So we believe that the evaluation of this evaluation methodology for high-tech regulation is I think we have similar approach. We can take the similar approach like this.
Okay, thank you very much again. And if there are no further questions, I would leave the floor now to Laura and Antonio, since they're fully in line with the topics that we have so far deepened together. They will give a speech on data sharing and voluntary licensing model from friend towards friends, and I'm sure they will explain in fully details what they're meaning with that. Antonio is an adjunct professor at the Lewis University, whereas Laura is a PhD from the University of Warsaw. So I leave the floor to both of you, and thank you again.
Okay, thank you very much, Professor Falce. Antonio and I were very much looking forward in sharing our research, which pursued the goal of developing a new model of friend that we call friends, in the sense of a friend model that is able to incentivize data sharing between companies. So our starting point is that one of the major weaknesses of European data economy is the lack of data sharing conducts between companies. In this sense, of course, in order to increase the innovation generated by the European Union data economy, we also need to increase the data availability. So data sharing is one of the main drivers we should focus on in order to foster database innovation. And this is, of course, a recurring element of all the communications that the Commission published until the last data strategy of February 2020. And I think it's important to go quickly, but also to stress that the major peculiarity of the data economy is that we can extract additional value from the same data set. What we mean is that one of the defining aspects of the data economy is that the same data set can be used by several players in order to extract different forms of innovation. So a second company using a data set of a first company can put in place an innovation activity which is completely different from the one carried out by the first one. So the additional value can be extracted from the same data. So we were asking ourselves, having framed the fact that data sharing is a residual activity within the European data economy, what could be the role of competition law? And the first part of our working paper is what we define the destructive part. So we were trying to figure out what could be the role, and in our opinion, the starting point is, in general terms, we can agree that antitrust law and competition authority cannot affect the structural characteristic of a market, not even data-driven market. And therefore, they cannot intervene in the sense of lessening the cost for accessing data. And this is, of course, corresponding to the general principle of freedom to trade. So, of course, antitrust law can have a role in the data economy when we have collusion, exclusion of market competitors, and other categories that our colleagues already mentioned in the previous presentation. There is one exception to this, which is the so-called essential facility doctrine, of course, where a dominant firm can be obliged to provide access to a specific facility when specific requirements developed by the case law recur. So, of course, it's not easy to summarize all the debate and the case law on the essential facility doctrine in one slide, but I think it's very important just to stress that we usually define 4 main parameters that should be demonstrated in order to mandate the access of a facility. Of course, the first one is that we have a refusal to access a product or a service which is indispensable for a downstream market. This refusal excludes effective competition in the downstream market. We do have consumer harm, and the original holder of the data set is not able to provide an objective justification for such a refusal. So we were trying, as a broad part of the literature did, to apply the essential facility doctrine to data, and the characteristic of data as an asset are making it difficult to apply the essential facility. First of all, data are defined as visitors in the sense that they are constantly generated by user. They usually are considered non-rivalrous in the sense that the fact that a data is in a data set of a company does not prevent the same data to be held by other companies, and the value of data usually depends from their age. So we used to say that the barriers to entry to digital data-driven market are not very high. So we were trying to apply the essential facility doctrine in the data realm, and we can borrow by the literature mainly written by ASCOLA scholar that help us in understanding that the essential facility doctrine does not apply very well in the data realm. So the two premises of the, let's say, destructive part of our paper are that antitrust law per se does not intervene on the structural characteristic of the markets, and that the essential facility doctrine as it is does not fit well the data realm. And this is where we start our, let's say, constructive part, trying to figure out how to develop a new friend model ad hoc for data sharing.
Okay, thank you, Laura. I think I will take it on from here. So thank you everyone for being here. And as Laura was underlying, we decided to engage and to evaluate whether the friend licensing system could be applied within the data economy. That was actually our starting point for the discussion. Of course, we do not need to explain what friend licensing agreements are. Actually, they're agreements based on fair, reasonable, and non-discriminatory characteristics, and so commitments to actually to provide license regarding essential patents. And we wanted to understand whether the friend licensing system could provide a yardstick for evaluating the data set roles and value. So going to the next slide, when we started actually analyzing the traditional friend scheme, that is something that the main literature on the topic already did when investigating the characteristic of the data market, we observed some difficulties in merely applying the friend traditional system to the data realm. So summarizing very briefly, very shortly, the differences that led us actually to modify our approach to the friend scheme. One very clear difference is that there is not currently, data and patents are extremely different for very specific characteristics, and there is not a clear definition of what currently constitutes a standard data set. Also considering that it's not a data set per se that can be considered standard for an area, but it's actually the specific set of data considered for the service to be provided. So actually there are differences in the specificities of the goods that we are considering and of the negotiated assets. Also, we observed significant differences in the structure of the relevant markets and in the role and modus operandi of big data companies that are not actually comparable to tech companies and companies engaging in patents activities. That is because economies of scale operates quite differently in the data market, and also the situation for data is unprecedented for patents because patents are not so fungible as data actually are. The discussion on the so-called commercial power of big data companies was significant in order to observe that data provides some sort of a wide entry to different markets, which is difficult to evaluate according to the traditional friend scheme for patents. And lastly, of course, the different structure and the different role of standard settings of organization creates for that the absence of generally shared rules on what parameters should be necessary for a data license to be considered fair, reasonable, and equitable. So if we go to the next slide, we can actually see that in a functional perspective, we evaluated that it was actually possible to identify a statistical relationship between specific data sets and relevant markets substantially on the basis of a case-by-case analysis that moved from the traditional friend agreements and adapted all the elements that we deemed critical. So the notion of standard, the adaptation of existing friend terms, the individuation of the dataset, and the estimation of the dataset value to the data market. And therefore, we operated a critical reassessment of the friend traditional model, and we decided to design a model of fair, reasonable, and non-discriminatory sharing agreements, that is our friends or friends. So a set of ad hoc friends licensing terms to regulate business-to-business data sharing. And in the next slide, we can actually see that in order to develop our friend system, which is of course still ongoing phase, we develop a 5-step strategy that we are currently conducting. So first and foremost, we operated a collection and an analysis of the main friend agreements employed by tech companies. So we went to evaluate the Google friend agreements, the Huawei technologies, and in doing so, we had a significant access also to documents that were related to previous litigation. For example, Huawei had, of course, a huge litigation on its friend terms that was substantial for us to access actually to the documentation pertaining to the agreement. And of course, we added also some open access license agreements that are extremely important because, of course, they are more easy to be functionalized to the data market. Of course, open access has always been a fundamental resource when we talk about data, and therefore, open access licenses, so for example, the Apache license proved extremely useful to adapt traditional licenses to the data market. Then, on the basis of these two elements, in the third step, in the next slide, we operated taxonomy and a classification of these characteristics. So we operated an overview of what was on the market and tried to find the characteristics and to regroup all the provisions existing in front on the basis of their goals and protected values. So, for example, clauses related to non-discrimination, or the clauses related to how the reasonable royalties are determined, or how the apportionment requirements are set, or which clauses do pertain to the exclusivity rules. And we try to figure out how to adapt and modify these clauses in order to make them fungible to our needs. So, in the last step of our analysis, in the next slide, we adapted this provision, but we did not merely adapt them on the basis of the characteristics of the data, but we also integrated this set with all the values that are specific to the data market and that are not found in the patent market. So, for example, we got some evidences from collateral bodies of law, such as the Open Data Directive and other bodies of law pertaining to the data realm, in order to functionalize our clauses to the protection of those bodies of law, also of law as well. So lastly, as we can see in the next slide, we concluded that by leveling, that's the last slide actually. So for concluding, we observed that by leveling on the main characteristics of existing friend agreements, and by providing a systematic adaptation and requalification, we are actually able to functionalize the traditional structure of friend agreements to the data market by creating a brand new model that can provide concrete guidelines for fair and reasonable agreements in data sharing. Thank you so much.
Thank you very much, Antonio and Laura. Grazie davvero. And very original, very interesting topic and presentation. So I understand that at least in Italy and in Europe is almost lunchtime, but I was wondering whether there are some questions, comments, or suggestions for this presentation. Well, if not, I have a question for you both. Which is, in your opinion, the most suitable status? So, who should be the subject implementing and adopting this new type of scheme? Do you think that the market should be left in the position to opt to adopt it? Do you think that it should be a hint for our judges and European courts, or do you think that there is some room for possible forms of co-regulation in this respect?
Yeah, okay. I don't know if Laura wants to take this in, otherwise I will go.
Yeah, you can go and then I will. Maybe.
Okay, so let's just start. Thank you for the question, which is actually extremely relevant because, of course, the policy aspect is significant to be implemented in the last part of the paper. So I actually, I am a bit, maybe I do not fully agree with Laura with that, but we will figure out eventually. I am not that confident in the ability of the market to reach this goal autonomously. And this is because, differently from the patent market or in general the innovation field, the data market right now is strongly concentrated. I mean, it's not an oligopoly in my view, but we are pretty close to that. We have few extremely big data companies that would not be, I mean, let's say, willing on their own to let access to data. So they are not doing it now, and I don't see them doing that in the future. I necessarily see some form of command and control regulation going from that. I'm not either that sure that actually courts can promote that alone. I do see a role of the legislator in that. I'm not, I mean, I see some necessity for the iure condendo perspective, actually. So for a form of normative intervention, even by setting up a standard setting organization, but some form of positive intervention, I would say.
If I can add just one element, when we were discussing together the fact that we miss standard setting organizations in the data field, of course, I was also thinking that maybe we can consider about having some sort of consortium among data holders. So the idea of having some sort of sharing models on voluntary basis of players holding, let's say, relevant data set for other players in the market. So I would imagine some sort of private coordination on that.
Yes, and I also guess that in the financial sector, something not very far from that has been already adopted in the sense of the fintech regulation. So, well, thank you again. Are there further questions or comments? If not, I thank you, each of you, for having joined this session devoted to big data and competition law. It has been a pleasure to chair it. I'm sorry that even if we pretend of being expert in technologies and digital environments, I was not able to share my screen and to say hello with my face and with a smile and with a hand. Nevertheless, I will try my best for the following sessions to recover my problems. I thank you once again for having contributed. I will then leave you, and I guess that we have a couple of minutes before the second panel will start. So I thank you once again, and arrivederci. See you in a little while. Bye-bye.
Thank you.